Okay, I think we can go ahead and get started. We are looking at 9:01 a.m. So good morning, everyone. Welcome to our November Focus event. My name is Ashley, and I'm an attorney on the team here at Equinox. Today, we are focusing on the hiring process and avoiding legal landmines in hiring. In this very challenging economic climate we are living in, it is very important that we are hiring the right people while, of course, avoiding any legal liability that can arise in the hiring process. So we're going to walk through some of the critical points that we want to make sure that we're aware of when we are hiring new employees. I do want to say that we are recording this presentation, so it will be posted on our YouTube channel, and we will send it to all of the participants after the event. You can feel free to submit questions throughout the Q&A through the chat or through the Q&A or the chat function. We may not be able to get to them during our program, but we will try to, or we will follow up with you after the webinar to answer any questions. A quick legal disclaimer before we get started. This presentation is for informational and educational purposes only. This is not legal advice. Of course, always consult with an attorney regarding your specific circumstances before taking any action or refraining from any action. Additionally, I do want to let you all know that we are a law firm in the state of Washington. So many areas of law, including in employment, are governed by both federal and state laws and regulations. Our presentation today will focus on Washington law. So to the extent that you're hiring employees in other states, it will be important to understand how the different laws would apply in those states. And finally, our discussion is going to focus on the process of hiring individual employees and not necessarily on the steps of becoming an employer, becoming a business who employs employees. So you will want to make sure that we understand the steps that you need to take in order to become an employer in the first place if you are just looking at hiring your first employee, either ever or your first employee in a new state. You want to make sure that you take those steps before you hire your new employees. These steps might include things like registering as an employer in the applicable state, obtaining workers' comp or unemployment insurance, posting employment policies in your workplace, getting ready to run payroll, those sorts of things. So we're not really gonna focus on those today, but just know that if you are looking at hiring your first employees or starting to hire employees in new states, which I know is becoming a popular question, you'll want to make sure that you're aware of any requirements before you hire employees in a new state. Okay, here is our agenda for the morning. Today we are going to be focusing first, we're just going to give the lay of the land on the stages of the hiring process. Next up, we're going to talk about what rights do applicants have. So we all know that employees have rights once they become employees, but there are also rights that apply to applicants who are in the hiring process. Next, we're going to focus on a few common mistakes that employers make in the hiring process, and then we'll focus on some key issues, which I'm sure if there's any questions throughout that process, that's probably where they're going to come up. So we'll focus on some of the issues that we hear from clients more frequently. So first, the stages of the hiring process. Now, it can be tempting when hiring a new employee to jump right into recruiting and searching for candidates. Immediately post the job description and start searching and interviewing. But it is important that there are a couple of steps that you want to take before that. So we want to consider all of our needs before writing the job description, as well as when writing the job description. For example, what type of position are you hiring for? What type of screening and job requirements are necessary? And what are your priorities as a business? There's sort of a standard job description that we're really used to seeing, but if you are really focusing, for instance, on culture and diversity, you will want to, you might want to make your job description look a little bit different than what you would typically see. There are also, ways to increase those diversity and hiring initiatives. So, we want to think through sort of where are we going to go to search for employees, and how does our identity as an employer come off on things like on our website? Is diversity really shown as something that we care about on our website? And so is that what candidates are going to see? So we're really thinking about how does our whole sort of nature as an employer come off to the folks that we are looking to hire. Additionally, we want to make sure that any requirements that we are setting for this position are clearly communicated and are based in sort of a reasonable need or a legitimate need of the business, and that those can be justified. And we're going to talk about that in a few different places today. Applicant rights. So of course, we know that employees are protected from discrimination. This is also true of applicants in the hiring process. So any employer is going to be prohibited from discriminating, which means taking any adverse action in making employment decisions against an applicant or an employee, of course, based on their membership in a protected class. And we've got some of those protected classes listed here. Those protected classes are going to be based on both federal and state law. So what we've got listed here includes some of both of those, including sex, race, color, religion, national origin, sexual orientation, all of those. And so, in particular in Washington, we have what we call the Crown Act here, which is actually just recently passed this year, that prohibits discriminating based on traits that are historically associated with race, including hair texture. So we want to make sure that we are aware of any, again, state-specific requirements here when we are kind of looking at hiring. Now, there is an exception here that you can I hesitate to use the word discriminate, but you can make employment decisions based on bona fide occupational qualifications. Now, those are going to be rare circumstances and very narrow, so we want to make sure that we're aware of what those might be. Just a couple of examples here. For instance, if you're hiring someone to model men's clothing, you can search for men for that position. Mandatory retirement age for things like law enforcement or someone who's operating heavy machinery where sort of fitness and safety are concerns. And then also requiring bilingual skills if those are needed for a job. Any of those are just examples of bona fide occupational qualifications that might result in making a hiring decision that might otherwise be considered discriminatory if that didn't exist. Some common mistakes that employers make in the hiring process. So the first thing that I'm going to focus on here is the job description. We're going to focus on a number of different areas in the job description where it really plays an important role in the hiring process and ensuring compliance as well as mitigating risk. So when we're drafting the job description, we definitely don't want it to be a one-size-fits-all. Every position should be considered unique, and we want to make sure that we're really thinking through what are the requirements and the needs for this position when we're drafting it. Failing to think through the process and developing best practices. So, we don't want to just jump into hiring without really thinking through the full life cycle of the hiring process. So that includes, from the very beginning, before you've even drafted the job description, thinking through what are our hiring needs. Once we've identified a position that we want to hire for, determining what is the salary range, what are our actual requirements and business needs, what type of screening measures are we prepared to take, and how are we going to do that? Failing to train our HR employees and hiring managers and interviewers. So this is a really important step that I think a lot of employers sort of forget to take or forget might be important. Some of the, I would say that most of the time, non-compliance in hiring is not a result of, sort of a malpractice or an unwillingness or sort of intentional discrimination or anything like that. It tends to be more situations where folks just didn't know. And so, you made a mistake completely unknowingly. And so we want to avoid those mistakes wherever possible. So when we are, having folks interview employees, we want to make sure that they understand, what types of questions should we not be asking, and making sure that they understand sort of what are the basic rules around discrimination, and as well as, in this age of, where diversity and inclusion are really important initiatives, how do we make sure that we're really integrating that into our culture and, training our folks on unconscious bias and things like that can come up during the hiring process. Failing to collect and maintain documentation. Of course, this is all about balance. We want to make sure that we are maintaining documentation, that when we're interviewing and making hiring decisions, that we are keeping some notes and documentation about why we're making certain decisions. Of course, we don't want those notes to then become a liability to us. So we want to make sure that, in addition to training and actually making sure that we are compliant, that the notes that we're keeping are not exposing us to additional liability. Additionally, there are going to be some documentation retention requirements. So for example, job applications need to be retained for at least a year. Employment documentation just generally should be retained for anywhere between 3 and 6 years, depending on the type of documentation and the jurisdiction that you're in. For example, payroll records in the state of Washington need to be retained for at least 3 years, and any documents related to unemployment, taxes, or employment tax should be retained for 4 years. So those are just a few examples here that we are maintaining documentation on each individual. Using a one-size-fits-all approach, I kind of touched on this already, but every job is different. And so the hiring process should be tailored based on the job and the employer's needs. Additionally, each applicant should be viewed as a whole employee. We want to avoid making any blanket rules or blanket policies that will be applied to every single person, because there might be circumstances where we need to take those into account when we're making our hiring decisions in order to avoid discrimination claim or just a non-compliance with regulations. Treating remote hires the same as local hires. So again, state laws are going to vary. So we want to be careful that we have investigated and implemented any requirements for each state. So particularly, I would say that states such as California or New York that are heavily regulated, especially in the employment space, we really want to make sure that we understand before going into those states what it means for us to become an employer in those states. I would say almost every state, becoming an employer would be considered doing business, quote, in that state. And so we're going to be, creating nexus. And so we have to think through things like, is that going to require us to pay business taxes? And what are the employment requirements in those states? So, here in the state of Washington, we have, for instance, paid family medical leave. That doesn't exist everywhere. So if you're an employer in a state that doesn't have paid family medical leave, it might not be something that you're prepared for or that you really know how to apply or implement if you go into a state that does have paid family medical leave. So there are going to be some different steps that you need to take if you are hiring employees in remote states, or if you have employees who are looking to move to a new state. That's also something that you should consider before going ahead and improving that. Okay, let's talk about some key issues here for employment when you're hiring employees. The first thing here is going to be the employment status. Now, this is a question of really, even before you get to the question of the qualifications of an employee that you're looking for, is whether you're even hiring an employee at all. So we get this question a lot, and we see a lot of missteps in this area. Folks say, should I hire a 1099 employee? Well, there is no such thing as a 1099 employee. In fact, there is sort of two categories of workers. Those are independent contractors and employees. And of course, an independent contractor, the tax form is a 1099, so that's how we refer to them as 1099s. But an independent contractor is not an employee. In fact, it's a contractual relationship. And so we want to make sure that we have properly classified our workers when we are hiring them to perform services for us. So an independent contractor, here's just some language from, this is actually from the IRS website here, that the payer has the right to control or direct only the result of the work and not what will be done and how it will be done. So that is, if it were an employee, that is sort of the nature of the relationship where if they were an independent contractor, that's what it would look like. So you're paying the worker and they're truly independent. So, a really great example is an IT services company. You pay someone to come in and perform IT services for your business, but they have other clients and they're operating their own business. They are truly independent. So that's a really easy example. If they have their own employees, so that might, that's where it's a really clear cut, they're clearly an independent contractor. Where it gets a little bit fuzzier is when we're hiring individuals who don't necessarily have fully formed businesses. Are they really truly operating independently, or are you going to be directing how and when and what the work will be done? So some of the language that we're seeing here is in this space, which is constantly evolving. I will say that even just recently in September, the DOL issued a new proposed rule here with different factors, is that we really want to look at the economic reality of the situation. So as an economic reality, is the worker in business for themselves, or are they economically dependent on the employer for work? A couple of the factors that the DOL, for instance, has said that they're going to look at here is the nature and degree of control over the work and how that work is done, as well as the worker's opportunity to experience profit and loss from that work. So again, in the concept of an IT services company, they are getting paid to perform the services, and if they don't do it well, they could take a loss on that, or if they don't price it right, they could take a loss. And so there is opportunity there for profit and loss, versus an hourly worker, for instance, might not experience that same opportunity. This is a quote from one of our blog posts by our managing attorney, Michelle Baumberger. If the role is one where you want to manage the what, where, and how of the worker is likely an employee. So we want to make sure that we have properly classified them before we've even gone into the process of hiring. And then next is exempt versus non-exempt. So this is how we pay the employees. This is just sort of a difference in employment status. An exempt employee versus a non-exempt employee is referring to application of minimum wage and overtime law requirements. There are different tests to determine whether an employee is going to be exempt versus non-exempt. And we want to make sure that we understand that at the beginning before we hire them, because it's going to determine how we pay them and how we structure the pay model. So there are certain duties that the employee needs to be performing based on the type of role that they're going to have, as well as there's certain salary requirements that they need to meet in order to be considered exempt. So of course, talk to an attorney before you hire an employee if you're not sure which of those would apply here. And then one other thing I'll mention here is that the salary threshold test actually is different if you're looking at federal versus state law. So come January 1st will be the first time that Washington state law will, that the salary threshold will exceed the federal threshold. So if you haven't looked at that in a while, you'll want to go ahead and look up what those new thresholds will look like. If you think that that might impact your employee's exempt status, you might need to make some adjustments. Okay, so next up, we're going to talk about discrimination. I know we've touched on this a little bit already, but just some best practices for avoiding discrimination. As I said before, most discrimination is not going to be blatant or intentional. More often, it's done with good intentions or just out of not knowing that something was a violation. So some best practices here is we want to make sure that we're performing regular reviews of our hiring documentation. And I would say at least annually that we're reviewing our whole hiring packet, everything from our job description to our job application, and even our interview questions, if you have sort of a framework for interview questions. So, employment laws are always changing, especially, in 2019, I would say we saw a ton of different legislation and changes to our employment laws just here in the state of Washington. So we do want to make sure that we are performing an annual review and making any adjustments based on changes in the law. I mentioned already, we want to train all of our hiring personnel who are involved in the hiring process. This is something that should be done regularly, as well as if anybody is going to be taking on sort of new or different roles in the hiring process as well. We want to implement written policies that relate to anti-discrimination and anti-harassment. So these policies should be clear, and we want to make sure that we really do follow through with them. So if we ever do experience a claim of discrimination, that we actually investigate those thoroughly and that we take steps to ensure that, that we're following the policy and that we're evenly applying those policies across our employee base. Establishing consistent interview questions. We want to make sure that, it feels good to kind of get into the small talk and really feel like we're getting to know our candidates through the hiring process, but we do want to establish some consistent interview questions in order to ensure that, that we're not sort of running afoul or having some inappropriate conversations that can easily gear towards things like an employee's age or their intention to have a family, those sorts of things that we want to avoid when we're in those initial hiring conversations, that are questions that we shouldn't be asking. And it can get we can unintentionally veer into waters that we shouldn't be in. So we want to make sure that we're kind of setting some guidelines there, and making sure that our folks who are doing the interviewing are aware of what questions that they should not be asking. Some of the do not ask questions, these are just some examples, but what year were you born? What year did you, fill in the blank, graduate high school, for example? Do you have, or do you want to have, do you plan to have children? How many children do you have? Just sort of anything that is kind of, seems like we're kind of fishing for information about a candidate's intention to have a family or have children. Where were you born? Where did you grow up? Do you own a home or do you rent? Are you married or single? Have you ever been arrested? Are you a U.S. citizen? So any of those types of questions are things that we're going to want to avoid. We're not trying to pry into somebody's membership in a protected class is really what it comes down to. And then we'll talk a little bit about salary, but we certainly also do not want to pry into how much did you make at your last job. There are some restrictions here in the state of Washington that were just passed in 2019 that restrict us from asking about salary, and we'll talk a little bit more about that as well. We want to implement some diverse recruiting and hiring practices at all levels. So, we've talked, I think, a little bit about this already, but having, really intentional practices where, what does our website look like? What are some ways that we can be reaching out and actually, making a consistent and an intentional effort to be hiring diversely, whether that's posting jobs in new places, or, making sure that we don't have any language in our job descriptions that might unintentionally isolate certain categories of candidates. Ensuring that our selection criteria are directly related to the position. So if we're looking for somebody who, an entry-level data entry individual personnel, we're not going to, require a master's degree, for example. So making sure that the selection criteria that we have are actually directly related to the requirements of the job. And we want to, this could be an issue of discrimination as well as an issue of just, it's going to isolate candidates that might otherwise be really great for the job. We're going to perform regular self-assessments and audits. Of course, we want to do this under attorney-client privilege whenever possible. So talk to your attorney if you are looking to do that. But things like looking at our employee pay scales and our hiring practices in general. If we're performing those regular self-assessments and having our documentation reviewed on a regular basis, then we're going to make sure that we're sort of keeping everything in line, and not sort of, over a number of years going awry. One really timely example of just unintentional discrimination that we have seen even just recently is we've had clients who have asked about, should I send vulnerable population home for folks who are in those categories of being vulnerable for COVID-19, or should we not hire folks who are, we've had even clients of staffing companies, for instance, direct the staffing company not to hire for vulnerable populations for COVID-19. And so that would be an instance of discrimination, and maybe even with the best of intentions, that we're not going to hire folks in this sort of age category or who have this type of underlying condition, but that is a discriminatory act that I would highly recommend against doing that. So we want to make sure that that even with our best intentions, that we're not accidentally running afoul of discrimination laws. ADA and reasonable accommodation. Now, if you're an employer or you've had employees, you might be aware that the ADA applies to those employees, but it can also apply to applicants in the hiring process. So employers are prohibited from discriminating against employees and applicants on the basis of having a physical or a mental impairment that substantially limits a major life activity, which is sort of the definition of a disability under the law. This also protects applicants and employees where the employer has a perception that they have a disability. So even if the employee does not have an actual disability, if they are perceived by the employer to have a disability, then they might have a claim if adverse action is taken based on that perception. Essential functions of a job. So this is an exception here, that the employee needs to be able to perform the essential functions of a job. In order to assist the employee to perform those essential functions, you as the employer may need to make a reasonable accommodation for that employee, which can look a number of different ways, but it's where the employer would be required to make an adjustment or a change to the role or how that role is done in order to accommodate an employee who has a disability to be able to perform those essential functions, unless doing so would constitute an undue hardship. So just some examples of what reasonable accommodations might look like in the hiring process. Those include, you might need to provide written materials in accessible formats, such as in larger print or braille or on audio tape, providing readers or sign language interpreters, ensuring that recruitment, interviews, tests, and other components are held in accessible locations. So for example, if you don't have an elevator in your building and you have an applicant who is in a wheelchair, then having the interview performed on the first floor of the building as opposed to the second floor, so that they can, come into the interview. Providing or modifying equipment or devices, and then adjusting or modifying application policies and procedures. So for example, if you have a software that you use to submit applications and that software is not accessible to folks with disabilities, then you might need to provide a different mechanism for them to submit the application. So those are just a few examples. There is an exception here where if providing a reasonable accommodation would constitute an undue hardship, then you are not required to do that. But I'd recommend, of course, documenting that clearly and consulting with an attorney to make sure that you have considered any alternative accommodations that you could make. An undue hardship is going to be anything that is a significant difficulty or expense, and I would say that this needs to be looked at on a case-by-case basis, because it's going to take into account sort of the size and the nature of the employer, and so that does not mean that anything that requires cost at all is going to be considered an undue hardship, only if it's a really significant expense for the size of your business.
Hey, Ashley, we do have a question that came in through the chat.
Okay.
It reads, if I have an employee who is afraid of getting COVID and is unwilling to come into work, what are my options if their work cannot be done from home?
Yeah, that's a great question. We're getting this question a lot these days. Obviously, this is not really a question about hiring, but an employee who is simply afraid of getting COVID doesn't have the right to just say, I'm not coming to work. Now, you as an employer have certain responsibilities under OSHA to maintain a safe and healthy workplace. And so to the extent that your employee feels that you haven't done that, then you might need to make some changes to your practices to make sure that you're doing everything that you can to keep that employee safe. But generally speaking, if you've done those things and a position cannot be done remotely, then you can require the employee to come into work. And if they don't, then you might need to find someone else to fill that role. Again, I would always, if anyone would like to sort of have a consultation about that specific scenario, happy to talk through what that looks like for that specific employee. Okay, so equal pay. So this is going to be a big one. Of course, part of the hiring process is determining how much are we going to pay this employee, how much are we going to offer them. And even in Washington, we do need to actually have the minimum salary sort of determined before we post the position. So equal pay for equal work, what's required here? Employees in the same workplace must be given equal pay for equal work. This applies to all forms of compensation, including salary, benefits, stock options, vacation time, holidays, anything of that nature. So really we want to make sure that, the full compensation package is equal for jobs that sort of are substantially similar. Job title does not matter. So if somebody, if two employees have substantially similar jobs or similar duties, then the fact that they have different job titles is not going to be determinative in any way. If there is a difference in compensation, we want to make sure that as employers, we have documented the purpose for that difference. We need to have a bona fide sort of reason for that pay differential. And it can be a number of different factors. It could be merit-based, it could be based on performance, it could be based on seniority. But if you are going to make those programs, then they need to be applied consistently. So to the extent that you are seeing sort of differentials in the pay for instance, men and women in your company, then we'll want to look at each of those instances and make sure that we don't have a pattern, or that that we do have sort of a consistent system for any differences in pay. And if you are seeing those and you're not able to justify that, or you are seeing sort of a pattern where consistently men are making more than women, or consistently men are being promoted more than women, just as an example, that we are really, being self-critical and making adjustments to our policies and practices in order to bring those things in line. And any differences, of course, should not be related to an individual's membership in a protected class, whether that be gender, race, etc. There are a number of different laws that govern equal pay, and those are both federal laws as well as state laws. So even an employee could have multiple claims if they believe that they experienced pay discrimination. They could have multiple claims under each of those different laws, and so it can be really costly for an employer to have discriminated in pay on the basis of membership in a protected class. We are prohibited here in the state of Washington as employers from seeking or inquiring about an applicant's salary history before hiring them. This also applies to employees within the company when you're making an internal hire or an internal promotion well, sort of, so that there needs to still be equal pay, right? So whether an employee is coming from outside or inside, those equal pay laws are going to apply similarly. When you're interviewing an employee, we want to, of course, avoid questions about salary history. And because this is a relatively new law, it was passed in 2019, your job application, if you haven't reviewed it in some time, may ask the employee to provide their previous wage or their previous salary. And so we want to make sure that we go ahead and strike that if there are any sort of outstanding fields in your job application. And salary and wage disclosures. So this is an interesting one. This came alongside the salary history ban last year. Employers with 15 or more employees who must provide the minimum wage or salary for the position upon request, once an applicant has been offered the position. So when you've offered the applicant the position, if they request the information, you do need to provide them the minimum wage or salary or a range that's been determined. So we should make sure that we have that documented in our documentation before we post the job. And then this also applies to internal transfers and promotions as well. So if an internal employee has been offered a new position or promotion and they request the minimum salary, then we need to give that to them.
Hey, Ashley, we do have another question in the chat.
Okay.
If I offer paid time off to one employee, do I need to offer everyone the same thing?
So I would say, I hesitate to say a sort of a blanket yes, but generally speaking, if an employee is given paid time off and there are other employees who are similarly situated, then I would think we'd want to think through the reasons that we're providing that particular employee with a different or greater benefit than the other employees. Sort of without more specific information, it's hard to answer that question, but I would say generally speaking, compensation should be equal when employees are performing the same job, unless we can justify a reason that is more merit-based or some other non-protected factor that would apply.
Okay, thank you.
Okay, background checks. So there are a lot of different types of background checks, and this is another area where we want to think about this before we post the job and when we're writing the job description in order to sort of insulate us from liability and mitigate any risk here. But there's a lot of different types of background checks. Probably when people hear the term background check, they're thinking of a criminal history check that most folks have performed by a third-party provider. But there's other ways to check backgrounds, including, reviewing an employee's or an applicant's social media pages, or calling references, doing drug screening, any credit checks. There's all kinds, driving record checks. There's all kinds of different background checks out there. So thinking through before we've posted the job, what type of screening are we going to apply to this position? And we want to prepare the job description with these needs in mind. So to the extent that you are going to require certain types of screening, you might want to provide some information disclosing that in the job description, or provide some sort of indication in the job description as to the purpose for including some of those things. So here in Washington, as well as in a lot of different states, we have what we call a ban the box law, which prohibits employers from asking about criminal history before determining that the applicant is otherwise qualified for the role. And there are a few exceptions to that, but they're fairly narrow. We are not allowed to make any blanket policies against hiring individuals with criminal histories or with felonies on their record. If we do perform a background check and we see that there is some criminal history, then if you're going to make an adverse decision in hiring that employee or not hiring them rather, then it needs to be reasonably related to the job duties. So just as an example, someone who's going to be a bank teller, if they have an instance of financial fraud on their criminal history, that would be reasonably related to the job duties when they're making that hiring decision. So they would be within their rights to not hire that individual. We need to obtain written consent before running a background check. So, if you are using a third-party provider, they should be providing some background check authorization. But there are some requirements there as far as getting that written consent. And then there also are some notices that are required before we take an adverse employment action, and providing the applicant with an opportunity to respond before taking that adverse employment action. And this is by the time you've already determined that they're otherwise qualified for the role. So most employers are going to wait until later in the hiring process when they've sort of either, are almost to making a hiring decision or have made the hiring decision before they perform a background check. Another type of background check is also a credit check. This is more rare. We don't see, most employers are not requiring credit checks, but if you are going to run a credit check, again, this is regulated. It has to be substantially related to the job, and you have to disclose the reasons for using a credit check. So this is an example where we would want to say something in the job description about not necessarily specifically stating that we're going to perform a credit check, but just sort of generally why performing a credit check, or what type of qualities would be required for the role that would make a credit check necessary. And of course, we're going to avoid making any automatic rejections or automatic decisions based on the outcome of that report, similarly to the background check. Reference checks. I don't have a ton to say here other than if you can't ask it of the applicant, you should not ask it of the former employer. So for instance, if you can't ask the applicant about their salary history, you also cannot ask their former employer about their salary history. Similarly, you can't ask about, if you can't ask the applicant about their disability or whether they have a disability, you should not be asking that of the former employer. And that's sort of just the general, a general rule that will help if you're performing reference checks. Now, some of those things are going to be important to our job, to our hiring process. We want to make sure that the person that we're hiring is the right person for the job. And, of course, there are going to be folks who are going to, to puff up their resumes, or, so we want to verify that all of that information is true and correct. So to the extent that you need to, verify that somebody used to work at a given, former employer, we do want to perform reference checks to make sure that we are able to verify all the information that we've learned throughout the interview process or in reviewing their resume. And there might be instances where a background check is absolutely necessary or advisable or even required. So we might want to perform a background check. I don't want to scare anybody away from performing any of these screenings, but just making sure that before we perform any screening that we've really considered, is it necessary? And if so, why? Drug testing. Okay, so drug testing is something that some employers require of their applicants before hiring them, or typically I would say again later in the process once they've made the hiring decision, requiring that an employee be drug tested. Pre-employment drug testing is permitted. Again, here I would recommend implementing a written policy, the who, what, when, where, and why. So who are we going to drug test? Is it going to be sort of a blanket, every single person that we hire needs to go through a drug test? What types of drugs are we testing for? Because of course there's different types of drug tests out there. At what point are we going to require drug tests? We're talking here about pre-employment drug screening, but there could be also drug testing policies for once the employees have been hired. So maybe a post-incident drug test if they're operating heavy machinery, for example, or if they're driving on the job. So there might be some different instances here where we want to make sure that we've really thought through a thorough drug testing policy. In any case, whatever your policy is, a drug test policy should be applied uniformly across all employees. We're not just sort of randomly selecting individuals for drug testing unless we, sort of have a regular random selection process, but that can get a little bit dangerous. And we want to make sure that we're not sort of picking out individuals for any particular reason, that we're applying our policies, of course, uniformly across the board. We want to disclose this as a condition to employment when we make the offer to the employee. So if we are going to require a drug test, the offer letter should say that that your employment is conditioned upon these things, and those things should include the drug test. ADA reasonable accommodation. There might be employees who are required to take certain over-the-counter medications or something that would show up otherwise on a drug screen. And so if those are not going to impair the employee's ability to do the job, then we might need to make a reasonable accommodation to allow that and to take that into account when we are reviewing the results of the drug test. Confidentiality. So the drug tests are going to be considered sensitive medical employment information. Those need to be stored separately from regular personnel files. If you have sort of a software system that all hiring personnel have access to, we want to make sure that we have a way to insulate that information so that not everybody can see it. And then, of course, you are allowed to adopt a drug-free workplace policy. We get the question about marijuana, even though it's legalized in the state of Washington. Are we allowed to prohibit use of marijuana? Yes, you can. So again, we just want to be consistent there with our policies. And then finally, the paperwork. So the biggest, maybe one of the biggest issues here is the paperwork involved with hiring an employee. There's a lot of paperwork, and what's required. So some of this is going to be, actual legal regulatory requirements, and some of this is just going to be something that we recommend. The first one here is just something we recommend, of course, is creating a checklist for your hiring process. We always recommend that you have a checklist for hiring as well as termination procedures that's going to include both information that is, sort of required across the board for all employers, as well as things that are specific to your company's needs. So for example, when an employee is hired, maybe they need to be issued certain passwords or an email address or a badge to access the building. All of those things you might want to include in your hiring process. And then similarly, when an employee is terminated, we want to make sure that we have a list of all of the different resources that we need to get back from them before they leave. Personnel files, we're going to maintain a personnel file on every individual employee, and those personnel files we want to make sure that we retain for the appropriate amount of time. Employees also do have, we sometimes address the personnel files in our employee handbook, and the employee handbook can say, for example, what we typically would say is if that an employee has a right to see their personnel file at least once a year, for example. Job description, we talked quite a bit about job descriptions already, but making sure that we really think through what is the job, what's the requirements, and making sure that the job description is clear on each of those points. And then the job application, just making sure, of course, that doesn't include any fields, it doesn't ask for any fields that that would not be permissible. So, for example, criminal history or salary. Background and credit check authorization. So if we are running any background or credit screenings, that we have the proper written authorizations to do that. Offer letters. So this it can be either an offer letter or an employment agreement or a combination of those, any sort of hiring agreements that we're going to have the employee sign. This is something that I would encourage you to have an attorney review before you submit it to the employee. And this is going to be something that we're also going to look at uniquely for each employee, because every employee is different. And so, for instance, the compensation package for one employee might look different from another. Some common areas that we see that we want to make sure are compliant, for example, are things like a commission policy, a commission structure. We want to make sure it's compliant with all wage and hour laws and minimum wage requirements. And so we want to make sure that those are accurate in the offer letter. Hiring paperwork. So of course we need the Form W-4. It's going to control employee withholdings. The Form I-9, which verifies authorization to work in the United States. And then the verification documentation. There are some unique rules with respect to COVID and verifying I-9 documentation if we can't do that in person, which is typically the requirement. Any employment agreements and new hire reporting. To the extent that you use a payroll provider, they might do your new hire reporting for you, but here in the state of Washington, we are required to report new hires within 20 days of hiring. Employee onboarding. So this is sort of where we get into your process is going to be unique to your company, and you might have certain, culture onboarding or an onboarding process that's really unique to your business. So you might have an employee handbook, you might not have an employee handbook. There are different sort of procedures for when an employee is given an employee handbook. For instance, if you have employees who are part of a union, you might not have an employee handbook, instead have a collective bargaining agreement. Culture and onboarding documents. So this is just going to be anything that's specific to your company, really bringing the employee in and making them a part of the team and teaching them sort of what's important and what are your values. Any IT and other resources, so providing the employee with their email address and their badge and all of those sorts of passwords and things to access any of the systems that they need to access. And then employee trainings, of course. So those are all the onboarding items that we're thinking of. So this is sort of an already a little bit of a hiring process checklist that you can use to get you started. But these are just some of the paperwork that we're going to be looking at creating when we are hiring new employees. And then resources. So because this is a fairly gets kind of in the weeds in the area of law, we of course draft blog posts. So these are just a few of the blog posts that we've drafted recently and posted that you can find on our website. So why the hiring process matters and how to do it right. Are you paying your employees correctly? How to stay compliant with out-of-state employees, and diversity and inclusion in the workplace, turning intention into action. So we've touched on all of these topics a little bit today already, but if you want to learn more information, then you can go to our website and look for these blog posts on our page. We do also have, I'll open up the floor to questions if folks have questions still, but we do have another focus event. Our December focus event is on December 10th, and we're going to be focusing on trends for the future. So this year has been a bit of a wild year for all of us. And so we're going to be looking at what have we learned from 2021 and from 2020, and what sort of trends are we seeing as we move into 2021. So it'll be myself and Michelle Bomberger, our founding attorney, who will be on that webinar. Do we have any other questions? I'll give a few minutes for folks to ask questions and submit questions through the chat. Okay, so if we don't have any other questions, I'll stay on for a few minutes here. And if, of course, if you do have any questions, feel free to submit them through the chat. But otherwise, if that's all I think that's all we have for today. And so everyone have a wonderful day, a wonderful Thursday, and we will see you next time.